Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. So, I am going to discuss a judgment where the importance of GD, General Diary, is there, but merely failure to make a mention in the General Diary so does not make the prosecution totally illegal, and actually the case need not be acquitted solely on the ground that the information was not entered into the General Diary. So this is what is stated by Honorable Justice N.V. Ramana and another judge in the case of Lok Atulya Police versus H. Srinivas. This is Karnataka State. 2018. On 18/5/2018, they have delivered the judgment. So when our Chief Justice was a judge, Justice N.V. Ramana and S.A. Nazir, Abdul Nazir. So both of them gave this judgment. So now first of all, let us know what is the General Diary. So according to section 154 CRPC, whenever information relating to a cognizable offence has been reported orally on rewriting to a police station, then the officer in charge of the police station has to register the FIR as a case, and he has to make an entry in the GD regarding the substance of the information he received. This is where the importance of GD comes. 1 minute. Okay. So this is what is called General Diary. Right. So General Diary. General Diary, please remember, in police stations, this General Diary has to be maintained. So according to section 44 of the Police Act 1861, the police officers are supposed to maintain, the SHO, that is police station in charge, is supposed to maintain the General Diary. So the timings of the General Diary are 7 a.m. to 7 a.m. That is, it starts from 7 a.m. of today and by 7 a.m. of tomorrow, because by 7 a.m. they have to hold the roll call. So in the meantime, what they have to do is they have to write the information, whatever is received in the police station. If they register a case, if any complaint comes, if any non-cognizable case comes, if any fellow comes and says that he has lost his glasses, like that they have to make an entry. So normally, in view of the court, General Diary is an important document and police give much preference to the same. To be frank, normally, since I also work as a police officers they do not give that much of importance to the General Diary. There are police officers who have not at all written the diary for 1 month, and who have written the diary once in a week, like that already. So at that time the poll will not be received. The writer and the SI, they will sit together, they will chart out and they will write all the General Diary. Even 1 week, 1 day they will complete it short. But in the eye of the court, General Diary is a record where every day entries, every time entries will be made. Right? So here the problem is, if now entry is made in the General Diary, then the case cannot be acquitted. That is what is stated in this judgment. So now we'll go to the Lok Atulya. You may be knowing Lok Atulya Police are definitely very powerful, just like our ACB in Andhra Pradesh. So Lok Atulya in Karnataka State. Actually, one chief minister, maybe Yediyurappa, I believe, he lost his job because of the chief minister, because of the Lok Atulya. So such a powerful organization it is. Right? Now, if you go to the facts of the case, this relates to crime number 103/2013. Yes, under section 13, clause 2 of the Prevention of Corruption Act 1988. So what is this? H. Srinivas, present the respondent H. Srinivas was working as an assistant engineer. So in a place in a Davangere district. So he amassed wealth. So the Lok Atulya Police, they conducted a preliminary inquiry. They came to the conclusion that he has amassed wealth. So he has got a disproportionate assets. Therefore, they conducted a raid. They found properties worth about 24 crores, where his legal thing is only some 24 lakhs or so. 24 crores he has amassed. Anyway, they have filed a case against him regarding the disproportionality. Right? Now, when the matter has come to the court, before the High Court, actually High Court quashed the FIR. High Court of Karnataka quashed the FIR under section 482 CRPC. Why? Because the advocate on behalf of Srinivas was able to convince the court, or he was able to argue that so whenever the police, maybe Lok Atulya Police, whenever the police receive information about the commission of a cognizable offence, they have to make an entry in the JD, then they have to conduct investigation. So here, entry in the GD, because Lok Atulya Police Station, I think they do not maintain any diary, but I am not sure. So anyway, entries were not made in the GD. So that is the main problem. But Supreme Court stated that. Preliminary inquiry, what is the purpose of preliminary inquiry? Definitely preliminary inquiry is an important aspect. Actually, normally, why preliminary inquiry is ordered? It is to check the mischievous people or mushrooming false petitions against the government officers. Actually, they misuse actually the process of law. They misuse the process of law for their personal vengeance and allege that this man has amassed wealth or things like that. So, by conducting the preliminary inquiry, you can know the basic facts, whether this man amassed wealth, whether the allegations are correct or not. So, they have conducted the preliminary inquiry. It was approved by the higher officers, Honorable Lok Atulya. He has ordered for the registration of the case. So, what more is necessary? So, simply relying on the general diary. After all, what is general diary? Information received will be made an entry. That is to say that they do not delay the matter. Here, they have taken their own time. In this connection, please remember the case of Lalit Kumari versus Government of UP 2014. There also, in cases of misappropriation or other things, a Prevention of Corruption Act, yes, the officers can do preliminary inquiry. Then only they can take action. They have done all these things except general diary. After all, what is there? Section 44 says the local police or the police have to make an entry in the general diary. So, if grave injustice is done, then definitely entry in the general diary is necessary. But here, besides that, the preliminary inquiry has been conducted, which is an important part. So, Supreme Court in category of judgments, they held that yes, preliminary inquiry is 100% accepted. So, definitely, they simply basing on the fact that no GD entry was made, the case cannot be acquitted. The case cannot be so-called discharged. So there is enough material, so let the trial go on. This is the order given by the Honorable Supreme Court of India. So please remember how the twists and turns will come. Normally, even in Mofsil courts also, they don't bother whether he made an entry in the GD or not. But here, basing on the GD entry, High Court has quashed the petition, and now the subject has come. This has happened in the year 2018. So very good judgment. Please, so police officers, it will be helpful for you. So not making an entry in the GD will not become fatal. It is only an irregularity. That's all, right? So please read the judgment and enrich your legal knowledge. Thank you very much.